Welcome to the Remedies video lecture series. This is lecture 5, and this lecture will discuss wrongful death, tort reform, and the collateral source rule. We will begin with wrongful death. At common law, all causes of action for tort injuries did not survive death. Personal tort actions terminated at death. As a result, the plaintiff who had died could not bring a cause of action resulting from his death. Likewise, the estate could not bring a cause of action. All actions terminated. As a result of this harsh treatment, there were several statutory remedies that were created both in England and then followed in the United States. The first of these were survival actions that we'll discuss shortly, and the second are wrongful death actions. Let's talk about survival actions first. All this does is that continues the plaintiff's rights to sue after they have died. The action is brought by the estate, and it's brought by the estate for injuries and damages that occurred to the deceased from the time of the injury or the time of the tort until they died. There is a limitation, though, to this. If death is instantaneous, there is going to be no recovery. There is no damage to recover from. There's no pain and suffering. There's nothing else to do. And in many states, including Ohio, future earnings cease at death. So there is no cause of action for future earnings other than the time of work lost between the injury, between the tort and the time of death. Future earnings do not continue after death. However, the survival acts, many survival acts, permit punitive damages. So if the defendant would have qualified for punitive damages had the case been brought by the plaintiff and the plaintiff had survived, the estate may bring the action and seek punitive damages as well. In addition, recoveries under a survival act are distributed through the estate. That is, according to the wishes of the deceased pursuant to their will or by intestate. Let's talk about wrongful death actions in contrast to survival actions. There are a number of questions that a wrongful death statute should resolve, and this will help you when you look at wrongful death statutes, because today wrongful death actions are statutory in creation. So the statute should resolve who brings the cause of action, because obviously the injured party is now deceased. Which survivors are covered? That is, who does the wrongful death action apply to that survived the deceased? What damages are covered? What is the statute of limitations for a wrongful death action? How are damages distributed? That is, who do they go to? And what is the relationship to the survival statute between the wrongful death statute? Okay, in Ohio, I'm going to use Ohio as an example of a wrongful death statute. The statute is 2125.01 through .04. The Ohio wrongful death statute states that the action is brought by a personal representative of the decedent, and this is a person who is appointed by the court to represent the decedent in the wrongful death action. And it's for the exclusive benefit, though. The wrongful death action is to collect damages for the benefit of several groups of parties. And the Ohio statute divides them into 3 categories: those that are rebuttably presumed to have been damaged, those who must prove that they were damaged, and those that are excluded. So let's take a look at these 3 categories for a minute. These are the people who either can bring the cause of action or who the cause of action is being brought for, or who are excluded from the cause of action. The rebuttably presumed damage group is the surviving spouse, the children, the parents. These individuals are all presumed to have been damaged when a tortious conduct brings about the death of a person. Those that may prove damages, so there's no presumption, are next of kin. So obviously all other relatives besides the surviving spouse, children, and parents. That would include brothers, aunts and uncles, cousins. Those that are excluded are a parent that abandons a child. If a parent abandons a child during the child's lifetime and the child is the one who is now deceased, the parent is excluded from recovery under the wrongful death statute. These categories are all fixed as of the date of death. Let's take a look at the statute for more information. Damages. The damages that are covered by the statute are compensatory damages and generally include the following: loss of support from the reasonably expected earning capacity of the decedent. This is what the decedent would have contributed to the support of the party seeking the wrongful death action. Loss of services. Loss of society, including companionship, consortium, care, assistance, suffered by the surviving spouse, minor children, parents, or next of kin. Loss of prospective inheritance. This is because of the death, the surviving individuals will no longer receive the same inheritance because the deceased can no longer contribute that amount to their estate. And then mental anguish incurred by the surviving spouse, minor children, parents, or next of kin. You will notice that in these categories here, the loss of society and mental anguish, that it's only minor children that are provided for. In several court cases, Ohio courts of appeals have held that next of kin includes brothers and sisters of the deceased and children who are now adults. More specifically, adult children are in this category next of kin and therefore may recover for loss of society and for mental anguish. The statute of limitations for a wrongful death action is 2 years from the death. The date of death starts the statute, and it's 2 years from that date. The distribution is by the court that appointed the personal representative based on equity with regard to the injury, loss, age, and condition of each beneficiary. If all of the beneficiaries of equal consanguinity, hard to pronounce, they can agree to distribute among themselves. So if all the survivors on the wrongful death statute, for instance, are children, let's say adult children, they could agree amongst themselves how it is to be distributed. Or if there were parents or just a surviving spouse, they could agree. Ohio provides for both survival and wrongful death causes of actions by 2 separate statutes, and neither precludes the other. However, in Ohio, loss of earnings and loss of earning capacity cease upon death, so they must be brought under the wrongful death cause of action in order to recover, and the individual bringing it must demonstrate the earnings that they would have received from the plaintiff had the plaintiff lived. Let's talk about tort reform for a minute. The Ohio Tort Reform statute is 23-15-18, and it classifies damages and gives a number of definitions before going on to limit certain damages. It classifies economic damages, which are wages, salaries, other compensation, expenditures for medical treatment, care, and other expenditures, basically for all damages that can be quantified in some way. Non-economic damages are non-pecuniary harm, including but not limited to pain and suffering, loss of society, consortium, etc. disfigurement, mental anguish, and any other intangible loss. It also defines occurrence as all claims arising out of one person's bodily injury. Now, what the statute does is it creates certain limitations, and in other categories there are no limitations. So let's talk about the categories where there are no limitations. There is no limitation on economic losses. Those damages or losses that are quantifiable, there is no limitation. So if the injured party suffered, $1 million worth of injuries, economic injuries, including hospitalization, lost wages, care, they would be able to recover for all of it. There is no limitation on economic losses. There is also no limitation on certain non-economic losses based on the injury involved, and these are permanent and substantial physical deformity, loss of the use of a limb, loss of a bodily organ, or permanent physical functional injury that permanently prevents the injured person from being able to independently care for themselves and perform life-sustaining functions. So as a result, there are no limits on non-economic damages for fairly serious injuries, based on fairly serious injuries. And these limitations in the Tort Reform statute do not apply to wrongful death causes of action. So let's take a look at now the limitations. The limitations are only on non-economic losses, except for those that I've just referred to that are fairly serious. So non-economic losses shall not exceed the greater of $250,000 or 3 times economic losses with a maximum of $350,000 for each plaintiff, or a total of $500,000 for each occurrence. So if you have an injured plaintiff solely on their own, their maximum amount of recovery would be $350,000. So it's the greater of $250,000 or 3 times their economic losses, but a maximum of $350,000. If there are several plaintiffs, so there's the husband who is injured, the wife who is seeking loss of consortium, the children who are seeking loss of consortium, together all of those plaintiffs could not recover more than $500,000 for the non-economic losses. Let's see how it's applied now, because the statute indicates several application issues. Either party can seek summary judgment on the nature of the alleged injury or loss, because remember, the nature of the injury is what determines whether there is a limitation on non-economic damages. So either party can seek summary judgment in advance of trial and therefore know where they stand. The jury is not informed of the statutory limitation by the court and cannot be informed by the parties either. The jury makes findings of fact and returns a verdict answering 3 interrogatories. Total compensation recoverable by the plaintiff, that is, they set an amount that the plaintiff should recover for their economic damages and their non-economic damages. They then go and list the compensatory economic damages and the total compensatory non-economic damages. At this point, after the jury returns its verdict, the trial court enters judgment for the economic loss and for the non-economic loss consistent with the limitations. That is, it takes the jury's interrogatories and enters a verdict for the economic losses listed. There is no limitation on those. And then, if the injury is not qualifying for no limitation, it then applies the statutory limitations to the non-economic losses as found by the jury. And the statute states the trial court does not have jurisdiction to enter a verdict in excess of the limitations. One last point to talk about is the collateral source rule. This is really 2 rules in one. It is the damage rule, which states that compensation from sources unaffiliated or independent of the responsible party are not deducted from the defendant's liability. Basically, what this means, if some other person, entity, has paid the plaintiff for injuries or losses that results from the defendant's tort activity, they are not deducted from what the defendant is liable. This mostly occurs when a person has either automobile or health insurance, medical insurance, and they pay for the injuries to the plaintiff, and now the plaintiff is suing the defendant. These payments by the insurance company are not deducted from the defendant's liability. The same would apply if the plaintiff uses vacation days for time missed for work, uses sick leave for time missed for work, which are all paid for by, in essence, the employer. The other part of the rule is an evidentiary rule, and this prohibits introduction of other sources of compensation. So at trial, the defendant could not introduce evidence that the plaintiff has received medical insurance payments and therefore is not really paying for the hospitalization out of their own pocket. So this prohibits introduction of that kind of evidence. In many jurisdictions, this common law collateral source rule has been modified by statute. If a jurisdiction has a pure common law collateral source rule, this information does not come in at trial. However, by example, Ohio has modified its collateral source rule, and by statute 2315.20 modifies the common law collateral source rule in several ways. Let's take a look. It permits introduction by the defendant of amounts payable to the plaintiff as a benefit, that is, the amounts paid by the insurance company, the sick leave time, the vacation time, with certain exceptions. When there is a mandatory federal, contractual, or statutory right of subrogation, or where there is life insurance and disability payments not paid for by the defendant. Now, the right of subrogation is really a right written into most insurance contracts. As a result, the insurance company has a right to collect back from the plaintiff any amounts that it has paid out that the plaintiff collects from a defendant. So if the plaintiff were to have incurred $10,000 in hospital bills that were paid by the insurance company and now collects that $10,000 from the defendant, the insurance company, through their right of subrogation, which is really a contractual right here, may collect that and seek that payment back. And in that instance, the parties cannot introduce evidence of this benefit. However, if the benefit is not required to be paid back, or isn't life insurance or disability payment not paid for by the defendant, then this information can come in. And there's one final piece to this that the collateral source rule sort of touches on but really doesn't quite resolve. In Ohio, write-offs, that is, when the hospital has a contractual arrangement with an insurance company to pay them less than the going amount. Many of you, if you've received information back from your insurance company, if you've gone to the emergency room, if you've gone to the doctor, if you've gone to the hospital, will notice that the hospital is charged $10,000 and the insurance company has paid $4,000. This is what's known as a write-off. And the Ohio Supreme Court has held that this write-off information, the fact that the insurance company only paid the hospital $4,000, the fact that the hospital only charged the insurance company $4,000, can be introduced to help the jury determine the reasonable medical expenses. So this write-off will come in as information to the jury. This concludes this video lecture. Remember, please, at the end, go to the Twin site and fill out the assessment for Video Lecture 5. Thank you.